Hello friends, Namaskaram, how are you? Har Har Mahadev, Jai Shiv Shambhu. In today's class, I will discuss about section 143A of NIA. The said scenario is quite common. Whenever we are going to contest a check bounce case, the application is submitted by the complainant against the accused with a prayer to incline the interim compensation. And if we are not able to defend the application in the proper way, the prosecution could have the undue benefit. So we have to understand the fundamentals, the defense strategy, so that we could easily encounter the applications in the due manner without getting any panic or anxiety. So directly I am moving on the board. I will specify you the points. Please observe them, and after the lecture, please try to maintain your record so that if you are having the resembling issue, the present notes could be helpful to you to make the proper reply and to defend the applications as per law. So we are moving on the board. In a check bounce case, for an accused, section 143A of NI Act is a problem, but I could say it is a big problem because it is concerned with interim compensation. And apart from that, the prosecution will emphasize that the application is to be inclined. If the application is inclined, the pressure is on accused to pay the amount. If amount is not paid in that scenario, he has to face the bitter consequences of section 143A of NI Act. So the primary question arises what to do, because the prosecution will emphasize on three fundamental points. Number one, the prosecution is strong, defense is weak, and delay is caused by the accused. If these fundamentals are on record and there is no effective reply on your part, then application will be succeeded 100%. So basically we have to understand the fundamentals. As far as section 143A of NI Act is concerned, the prosecution usually follows four fundamentals. Number one, it is assumption of prosecution that the case of prosecution is strong and case of defense is weak. But I want to clarify that the powers are not mandatory. It depends upon the discretion of the court, but discretion is to be exercised as per sound principle of law. And the legal position is sustained by Honorable Supreme Court of India. Judgment specification is 2024 volume 4 SAC page 419. Now we are coming on point number 2, that says the order is to be reasoned. The order should not be mechanical. If it is, then it is against law. That is section 393 of BNSS. And apart from that, there will be violation of Honorable Supreme Court judgment Indrajit versus Santosh. Judgment date is 19th of April 2022. Please be noted. And apart from that, the court has to record the basis of compensation. If it is not on the record, the accused could be succeeded. And apart from that, you must give reply. If your defense is not having the probabilizing effect and delay is caused by you, then you could not be succeeded. Now we will discuss the strategy. What to do? Whenever the application is filed by the prosecution, just read the application to find out whether facts are compromised or not. Number 2, we have to find out whether the pleadings are as per the guidelines of section 143A of NI Act or not. Number 3, we have to give the reply. And while giving the reply, specify that there is no delay on your part. Regarding this, you may rely on the order sheet. And apart from that, you may specify that you always cooperated with the process. And in addition to this, in the reply, you have to specify that your reply or defense is having the probabilizing effect. To understand this scenario, we will take an example. Mr. A gives rupees 2 lakh to Mr. B. That is the case. And Mr. B gives a check of rupees 2 lakh as per Mr. A. The check is bounced and ultimately prosecution is submitted. In the meanwhile, an application is submitted by Mr. A of section 143A of NI Act. While contesting the application, Mr. B submits that the amount is repaid or certain amount is paid, but the fact is not endorsed by Mr. A deliberately. So, if the said scenario is admitted or evident, the case of Mr. A regarding 143A of NI Act could be defeated. So, basically, in our reply, we must have the probabilizing effect. And despite of that, if the order is pronounced by the concerned court and we are filing a revision, we have to observe that whether reasons are specified or not. If order is mechanical or cyclostyle and there is no specification of delay on the part of accused, and even there is no basis of compensation on record, and apart from that, the court has abused the discretion, then we could be succeeded. So we have to understand the three fundamentals which are quite important. Number one, the court is bound to hear the accused as well. The court has to specify the reasons, and apart from that, the reasons must be supported with sound reasoning. If you find that the order is unreasoned, it is in limine, there is no sound reasoning, then you may challenge the order. And apart from that, judgment of Honorable Jammu Kashmir High Court is quite important. Judgment date is 20th of April 2026. So I think that things are not difficult. It depends upon us in which manner we are going to contest the application. So whenever the application is filed, just observe the application, give the proper reply. Your reply must have the probabilizing effect. And apart from that, you have to work out on the issue of undue delay or delay. And in addition to this, if there is any order, you have to emphasize that whether the discretion is as per the norms or not. And apart from that, whether reasons are recorded or not. If there is nothing and there is no due compliance on the part of concerned judge, then you may challenge the proceedings as well. See you in the next video.